A new ruling from a federal appeals court that ex-President Donald Trump can be sued in relation to the January 6th attack on the U.S. Capitol, rejecting his bid for sweeping presidential immunity against civil claims. Trump's team had previously argued that almost all of his conduct was protected while he was still an incumbent president, including on January 6th, and that this should shield him from lawsuits. But in their unanimous ruling, a three-judge panel concluded that, quote, the president does not spend every minute of every day exercising official responsibilities. And when he acts outside the functions of his office, he does not continue to enjoy immunity from damages liability just because he happens to be the president. When he acts in an unofficial private capacity, he is subject to civil suits like any private citizen. The ruling stemmed from a suit brought by a Capitol police officer injured in the riot, and at least 10 other suits like it have been filed by law enforcement officers and lawmakers. And although the ruling rejects Trump's immunity claim, it does leave the door open for Trump's team to prove in the future that on January 6th, he was acting in his official capacity. And with this extremely consequential ruling's impact on multiple other legal fronts for the ex-president, it is expected that his team will appeal it, potentially to the Supreme Court. And that is where we start this hour with former top official at the Department of Justice, Andrew Weissmann. From the New York Times, congressional reporter Luke Broadwater is here, and former chairman at the RNC, Michael Steele. Friends, it is good to see you all. Andrew, help us understand this new ruling, the impact it could have on Trump's myriad legal cases.
Well, everyone's eye is not on this case, but on the criminal case in Washington, D.C., because the allegations in that case revolve around what the former president did in his last days in office. So it's unrelated, for instance, to the Florida case where it deals with conduct after he was in office. So everyone's focusing on whether there was presidential immunity for the D.C. criminal case. And at least, as you said, the case today came up in connection with a civil case. And by its terms, it says it does not deal with a claim with respect to criminal immunity. But having said that, the tea leaves reading here seems pretty strong that the former president is going to not prevail either in the district court or in the Court of Appeals in D.C., so that his really remaining shot for presidential immunity is the Supreme Court. And that seems like a long shot in this case.
And I promise we'll get to the Supreme Court in just a second. But Andrew, just to underline what you said there about the criminal case out of D.C., the Washington Post writing, quote, the question of whether such immunity applies to Trump's federal criminal case in D.C. still needs to be weighed by U.S. District Court Judge Tanya S. Chutkan. That decision is also certain to be appealed. Andrew, your sense of when we can expect to hear from Judge Chutkan?
I hate to use the term imminently because Fani Willis used that famously in Georgia in, I think, January, but we didn't get an indictment until the summer. But I think that Judge Chutkan quite rightly was waiting to see if this decision would come down and provide guidance, because she is a district court judge in the same circuit, so that she is going to be bound by any decision that comes from the circuit. So having said all that, the answer to your question is I would think that we could expect a decision next week. She understands that this is the decision, the presidential immunity decision in her case is the one that will certainly go to the circuit, and it may go to the Supreme Court. And if there's one thing that could derail the March 4th date that she said is set in stone, it's that appeal process. So she is going to have every incentive to really get her decision out. But obviously, she's going to digest the work today of the circuit court in this civil case.
Luke, Andrew's use of imminently brings back warm memories of how politicos, judges, and journalists all have very different definitions and understandings of that word. So when you say next week, Andrew, I will take that as imminent. Luke, the New York Times writing this, quote, if Judge Chutkan rules against the immunity claims and Mr. Trump's lawyers challenge her decision, they will likely have to make a detailed finding to the appeals court that his efforts to overturn the outcome in 2020 were not undertaken as part of his reelection campaign, campaign, but rather in his official role as chief executive. Luke, any sense of how it would be that Trump's lawyers would try to make that case?
Sure. Yeah. I mean, well, they're trying broadly to have everything he did surrounded by January 6th covered as part of his official duties, that he can't be sued for them. Clearly the argument here on the part of these Capitol police officers, who I know and I've interviewed, and talk about the great trauma that they went through on January 6th, is that Donald Trump is to blame, that he wasn't covered by presidential immunity, that he was acting outside his normal duties as president when he amassed a mob on the Capitol and sent them into the building, inspired by his words. And they ended up attacking 150 police officers. The one officer in question, Officer Blasingame, who I spoke with, he was called racist slurs repeatedly, according to his account. He had to fight for his life. He didn't know if he would make it home that day. He still has long-lasting effects from the events of January 6th, and he believes that Donald Trump put those events in motion and should be held civilly liable for them. And so today's ruling was a victory, a temporary victory, a small victory, but a victory nonetheless for those officers who are seeking some form of justice from Donald Trump.
Right, Michael, I take Andrew's point that most people's eyes are not trained on this specific case, but rather on many of the other cases that we're watching with Donald Trump. I also take Luke's point that there were real individuals who were impacted by what Donald Trump did on January 6th and the days leading up to January 6th. Several of those Capitol police officers who were injured, they have given raw, emotional testimony to Congress. Take a listen.
That they continue to be a constant trauma for us literally every day, whether because our physical or emotional injuries or both.
I've been left with the psychological trauma and the emotional anxiety of having survived such a horrific event. And my children continue to deal with the trauma of nearly losing their dad that day.
January 6th still isn't over for me. I've had to avail myself of multiple counseling sessions from the Capitol Police Employee Assistance Program, and I'm now receiving private counseling therapy for the persistent emotional trauma of that day.
Michael, there is the collective trauma that we as a nation have experienced at the hands of Donald Trump, and there is that very individual trauma that those officers and their families have experienced. How important is it that they be allowed a legal mechanism to hold those responsible to account?
I think it's extremely important, and I think it's something that in the main, the American people want to see made available to those police officers, because they watched it. American citizens watched this thing unfold. They saw flagpoles being shoved into the faces of police officers. They saw barricades being lifted and thrown at them. They watched police officers getting beaten, squeezed almost to a lifeless state after, in between doors, being jammed up and objects thrown at them. We watched this. So the idea that there is no recourse available to them, there's no way in which they can receive justice, remunerative or otherwise, as a consequence of their service. I think it's important for the American people, and I think this ruling today says that in a very significant way. I took a step back after looking at this and said, the court just painted a very interesting box here by saying that the president in any 24-hour period is not acting in his official capacity all the time. All right. And then you have Trump and Meadows and others saying that they did act in their official capacity. So from a political standpoint, I'm saying, OK, so if you take the official capacity argument and that's what you were doing, all the more reasons why your behind should be nowhere near the Oval Office in 2024. Well, right? Andrew, because you, in your official capacity, tried to overthrow the government and wounded police officers serving in the defense of the Capitol in that process. So it's an interesting box that the court, I think, is set up. I'm looking again from a political standpoint. that in an analysis standpoint could be very intriguing in the argument that they want to make, because both are problematic. One is a civil lane that's opened up, and the political lane that also is opened more broadly.
Right, which is then it is an abuse of your actual power. Andrew, to this point, we've been talking about Trump's official capacity as president, but in the ruling, the judges said that Trump is not protected as a presidential candidate either, writing, quote, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next. And campaigning to gain that office is not an official act of the office. That seems like an important distinction to make there, Andrew.
Absolutely. What you just pointed out is the heart of the decision. It is that language that is going to be latched onto by the government in the Judge Chutkan case to say that is why there is no criminal presidential immunity in that case. The court had the distinction between the official actions, I'm reading now from the decision, the official actions of an office holder rather than the unofficial actions of an office seeker. And what the court said, as you pointed out, is you can be an office seeker and be the current president seeking a new term, or you could be somebody who was voted out of office, as was the former president, who's now seeking to be elected again. In either situation, you have to distinguish the conduct and the role that they're in. And everyone can understand that it with respect to the criminal case and what happened in the lead up to January 6th, that was all in connection with the former president's desire to stay in office, to win the election that he actually lost. So I think that this really bodes very well for the government, both in the district court and in the circuit court, that is the Court of Appeals, based on this decision today.